Stuart here at Public Law Hacks, where we bring you simple guides to public law issues. Please like the video and subscribe to the channel for more content. Today we have our top 5 must-read cases for revision in public law. Each case is important on its own, but we've tried to get cases that you can use as authorities for multiple revision topics to maximize your time. If you think that there's a case that's better, please leave a comment below. So, in at number 5, we have A and others versus the Home Secretary. In this case, the UK adopted the Anti-Terrorism Crime and Security Act of 2001, and this was used to detain certain foreign people in the UK indefinitely. They were detained because the UK would not bring criminal charges against them, and the UK could not deport them because there was a risk that they would be tortured in the country they would be deported to. However, it was considered that if they were free in the UK, it was believed they would commit acts of terrorism. Now, the Act allowed the Home Secretary to issue a certificate saying that they reasonably suspected a foreign national was a terrorist. The person could then either be detained indefinitely or allowed to leave the UK if they could find another country that would accept them. Detaining people indefinitely would normally be a breach of the right to liberty and security, but the UK was allowed to temporarily suspend this protection because of the terrorist attacks of the 11th of September 2001. This is called a derogation. Now, the court found the detention power in the legislation was incompatible with human rights law. They said that the threat of terrorism came from both foreign nationals and UK citizens, so it was unfair to single out just foreign nationals for indefinite detention. Also, by allowing the suspected terrorists to go to other countries, the UK did not eliminate the threat they posed to the UK, so the measures didn't deal with the problem that they were supposed to. The court issued a declaration of incompatibility against the legislation using Section 4 of the Human Rights Act. You can find out how the Human Rights Act works in our video on the topic. Now, this is a really good example of how the Human Rights Act works in practice, so it's really good for revision on that. It's also useful for revision on the separation of powers, with the courts intervening to limit executive powers here, and it's also quite a good case for revision of civil liberties and powers of detention. In at number 4, we have the Council of Civil Service Unions versus the Minister for the Civil Service. This case is also called the GCHQ case, which stands for the Government Communications Headquarters, which is a government intelligence and security organization. In 1983, the executive arm of government, without consulting the employees at GCHQ, altered the employees' contracts so that they could no longer join trade unions. A trade union and some employees asked the courts to review this decision. They said employees had a legitimate expectation to be consulted before changes like this were made, and as the government had not consulted, their decision was unlawful. The minister claimed that they couldn't consult employees because if they did, it would result in employees going on strike and damage national security. The court held that the exercise of this prerogative power could be reviewed by the courts, but that the court's ability to review decisions depended on the subject matter. This wasn't about the source of the power, but its nature. So executive decisions on entering treaties, deploying the armed forces, etc. could not be reviewed by the courts. Overall, the court ruled that it had the power to review the government's decision. The applicants did have a legitimate expectation of being consulted before their contracts were changed. However, considerations of national security outweighed the applicants' legitimate expectation of prior consultation, and the decision was therefore not unlawful. This is a really useful case for revising prerogative powers, particularly how they work and are supervised, for judicial review, how it applies and what its limits are, and also for the separation of powers, particularly the limits of judicial and executive powers. At number 3, we have Miller versus the Secretary of State for exiting the European Union. When the UK decided to leave the European Union, there was a question over who had the power to do this, specifically whether the executive arm of government could trigger the process for leaving the EU without first gaining the consent of the legislature. There were two conflicting constitutional principles at stake here. First, normally the executive has the power to sign up to international laws, called treaties, or leave them without needing to consult the legislature. That was what the government proposed to do in this case. However, the executive normally can't change a law passed by the legislature without their consent, and leaving the EU would inevitably lead to changes to the UK's domestic law. People would lose rights they got from EU membership, and laws like the European Communities Act of 1972 would be rendered pointless. The court ruled that it would be inconsistent with long-standing fundamental principle for such a far-reaching change to the UK's constitutional arrangements to be brought about by a ministerial decision or ministerial action alone. As a result, the court ruled that before the process to leave the EU could begin, the Parliament had to pass legislation giving the executive permission to withdraw from the European Union. There was a separate question about whether the UK government and Parliament could leave the EU without first getting the permission of the devolved authorities. There was a constitutional convention, the Sewell Convention, which requires the Westminster Parliament to get consent from devolved authorities like the Scottish Executive and Parliament when it wants to change a law that would impact their powers. It was argued that leaving the EU would impact devolved powers, and the Westminster Parliament needed to get consent from the devolved authorities before they could trigger Article 50. The court held that while seeking consent was an important part of the UK's constitution, the Sewell Convention was not a legally enforceable rule, and the Scottish Parliament had no legal veto over the UK's withdrawal from the EU. Now, this is a really useful case in revision on how the UK constitution can be changed, how devolution functions, constitutional conventions work, the separation of powers between the executive and the Parliament, and the use of prerogative powers, particularly the justiciability of treaty making. In at number 2, we have the Fire Brigades Union case. This case is really important for the separation of powers between the executive, legislature, and judiciary. In this case, the Parliament had passed a law creating a compensation scheme for victims of crime. Normally, as was the case here, legislation gives power to a minister to start the legislation once the government department is ready. However, the minister refused to exercise the power to start the legislation in this case and tried to set up a different compensation scheme to the one in the legislation using prerogative power instead. The Fire Brigades Union brought the case because they wanted the legislation and compensation scheme to start and asked the court to look at whether the minister was legally allowed to use the prerogative powers to create a different scheme. The court found that while the minister had control over when the legislation started, he could not say that he would never start the legislation, and by saying that, he had acted unlawfully. So by not implementing the legislation, the minister was going against what the Parliament wanted. The court held that the minister had acted unlawfully by doing this and exceeded his powers. We see the executive acting unlawfully by trying to stop the legislature exercising its rightful powers, and the court stepping in to stop and defend the Parliament's power. The court hearing this case was very divided on whether the court should be involved in this matter between the executive and the Parliament, and their discussion informs us about the nature of the separation of powers and the limits of judicial review. This is a really important revision case on how Parliament functions, the relationship between the Parliament and the executive, how the separation of powers works, and the scope for judicial review in this context. In at number 1, we have the case of Miller versus the Prime Minister from 2019. In this case, Gina Miller successfully challenged the lawfulness of the Prime Minister's decision to prorogue or shut down Parliament for a period of 5 weeks in the approach to the proposed exit day of the UK from the European Union on the 21st of October 2019. This case is important because it tells us about the scope of the prerogative power to prorogue Parliament, the relationship between Parliament and the executive, and the principles that underpin parliamentary sovereignty. In the judgment, all 11 justices agreed that proroguing Parliament was unlawful. The court rejected the government's two main arguments, which were, first, that the power to prorogue Parliament was non-justiciable or not able to be assessed by the court, and the second, rejected argument was that the prorogation was part of parliamentary proceedings and could not be questioned in any court under Article 9 of the Bill of Rights Act of 1689. Writing for the court, Lady Hale said, "A decision to prorogue Parliament will be unlawful if the prorogation has the effect of frustrating or preventing, without reasonable justification, the ability of Parliament to carry out its constitutional functions as a legislature and as the body responsible for the supervision of the executive." Now, this case is really important, particularly in the context of the exam for 2020. It gives you great details on how the separation of powers work, how prerogative powers should function, the scope of judicial review, standards of judicial review, and the remedies that are available for unlawful acts carried out by the government. So that's our top 5 cases for revision in public law. Thanks for watching the video. Please like the video and subscribe to the channel for more content.